Well, the sequel to last year's pre-4th of July Clarence Thomas Laser Eyes show did not disappoint. It's not quite of the consequence of last season's returning abortion to the states and affirming a Second Amendment right to carry, but a return to constitutional fidelity in at least one branch of the federal government is clearly in progress, with affirmative action in college admissions now dead, the First Amendment right against being compelled to produce speech affirmed, and lastly, on Friday, Joe Biden's made-up, legally dubious election ploy, student debt cancellation, ruled invalid and unconstitutional as well. All of these cases matter monumentally, but this last case on student debt cancellation has fascinated me since the program's announcement in August and the Supreme Court taking up the case in October, because it's something of a constitutional stress test. It's such a clear executive overreach, a seizure of power away from Congress, such a presidential middle finger to the legislative branch that if the court were to affirm it, it would be effectively a blank check for the president to do whatever he wants, however he wants, whenever he wants, as long as he can point to some loosely applicable statute in the nearly infinite mountain of federal law already on the books. And insofar as a third of the justices on the court view that presidential middle finger as legitimate, that concern remains very much alive, actually. But at least it doesn't win the day. Reading the dissent, though, I'm convinced that Joe Biden could announce a plan to gas his political opponents and cite "these old saggy senile nuts" as his statutory authority to do it, and Kagan, Sotomayor, and Brown-Jackson not only would fire up the trains, they'd lecture the rest of us for our constitutional infidelity if we have any questions about the boarding process. Anyway, recall at issue here is Biden's student debt relief program, some $430 billion in existing student debt canceled outright in the form of up to $20,000 per eligible borrower, which includes just about everybody who did borrow, with the Secretary of Education claiming his authority under a post-9/11 bill that allows the Education Department to adjust certain loan terms originally for military service members deployed in war, later expanded to include borrowers affected by national emergencies. And the authority to do this was discovered magically, not even during the height of the supposed COVID emergency, but right before the midterms, even though no move of this type or scale was ever even attempted in the 20 years of this law's existence prior, and even though Democrats generally acknowledged up to that point they had no legal authority to do it.
People think that the President of the United States has the power for debt forgiveness. He does not.
In fact, that very Nancy Pelosi quote was referenced by Chief Justice John Roberts, writing the majority opinion in this 6-3 decision. And the fact that John Roberts is writing these decisions in fairly clear terms, he also wrote the gay wedding website decision out of Colorado, is a good indicator of just how clear these cases are. The guy who's otherwise inclined to stretch every logical limitation for the appearance of compromise has perhaps finally had enough of that and is now saying, look, even I can't fluff this one. You guys are just wrong. And so it's a fairly straightforward case with fairly straightforward reasoning, save one wrinkle: whether the challengers actually have standing to bring the lawsuit, as in those suing must have a direct connection to harm in order for the lawsuit to be valid. For that standing reason, the court unanimously dismissed a companion lawsuit coming from two borrowers in Texas. They lacked legal standing to sue. Not the case in this case, though, where Roberts and the majority ruled that with particular respect to Missouri, one of 6 states suing in this case, Missouri has standing to sue because Missouri established MOHELA, a nonprofit government corporation that services loans. Missouri has a direct stake and therefore brings a legitimate challenge to Biden and the Education Department. If this lawsuit is valid in standing, then the primary legal question here is whether the outright cancellation of debt falls within what Congress meant when it gave the Secretary of Education the authority to, quote, waive or modify loan terms in times of national emergency for affected individuals. Roberts reasons this debt cancellation move can't be understood as a waiver of certain terms because the Secretary didn't even clarify which term he's waiving. It's just all of it. in general. And he's not just waiving certain terms. He's creating new policy outright. The waiving of one term of the agreement doesn't necessarily include the insertion of brand new policy made up on the spot, which is what the Education Department did with this arbitrary $10,000 or $20,000 debt cancellation figure. Roberts writes, this invented policy can't be included in the term modify either, because to modify means to make slight changes around the edges, not completely reinvent the entire law. Roberts writes, the Department of Education is modifying the law in the same sense that the French Revolution modified the status of the French nobility by chopping off its head. If you modify your car with a few parts to give it some more power, it's still a car, in other words. If you modify your car to go to the moon, though, well, now it's a spaceship. Now it's a fundamentally different thing. Congress wrote a law about cars, and now we're claiming actually they meant spaceships. In what is a radical departure from past implementation of this law, the secretary in this case didn't change just a few terms here and there to keep affected borrowers from being put in a worse position financially, as the statute demands. Instead, he fundamentally changed the entire program to give everyone a benefit, a move for which the statute gives no authorization. It was never a move made with fidelity to the original deal. It was Darth Vader treatment of the deal.
I am altering the deal. Pray I don't alter it any further.
And in this country, we don't govern by force choke, even if we really like who's doing the choking or who's getting choked. We have a prescribed body and process for lawmaking. That's Congress. And so if Congress's intent was the outright cancellation of student debt, Congress should clarify that and do it itself. That is the majority opinion summarized. And the dissent is hard to take seriously, not just for the absurd stretches to make this law say what they want it to say, but for the shameless ideological inconsistency from people who are absolutely smart enough to know what they're doing, or at least one of them is, the author in this case, and can't claim obliviousness as a defense. Elena Kagan writes on behalf of Sonia Sotomayor and Ketanji Brown Jackson joining in dissent, initially at length to deny that the plaintiffs have standing to sue, and then on the merits to say that clearly the statutory language of waive or modify means the Secretary of Education can do whatever he wants, whenever he wants, however he wants. After all, she writes, the court majority tries to separate these two terms into different things, waive or modify, when in fact they should combine forces like Captain Planet rings to create unaccountable superpower free from congressional or court oversight. Well, to the extent the statutory language is waive or modify, these are distinct things. Yes, waive and modify would imply a combination of the two. Regardless, I will grant the point that perhaps the language is unclear. Did Congress mean cut this and change that? Or did Congress mean cut this or change that? Well, since Congress didn't say that the Secretary has the full authority to just delete the law outright and invent a new one on the fly, I will say that is not what Congress meant. But granted, there is perhaps some ambiguity in this context. But where there is ambiguity, that is a question for Congress to clarify. As Roberts writes for the majority, the question here is not whether something should be done. It is who has the authority to do it. And where there are major questions of political and economic impact, those questions are reserved for the people's representation in Congress to answer. This is a decision that defers authority back to its proper constitutional arena. And so, of course, Kagan and company are going to twist that deferral into its opposite. That actually, this is the court seizing power somehow. Kagan, in a shocking critique of her own reasoning otherwise, writes that the court is exceeding its proper limited role. The court is substituting itself for Congress, putting its heavyweight thumb on the scales and preventing Congress from doing what it thinks is best. And here's the part I have to believe she was smirking while writing, because there's no way she had a straight face saying this given her inclinations in any other context of the law. Quote, "This court, by its design, is as detached as possible from the body politic. That is why the court is supposed to stick to its business and stay away from making this nation's policy. First of all, the court did not make policy in this case. It deferred policy making to the policy maker, Congress. Secondly, the Supreme Court doesn't and shouldn't make national policy. That's generally right. So now do abortion, Elena, because in the context of the Supreme Court inventing and imposing national abortion policy out of thin air and removing the policymaking process and decision from the precious body politic, when the Supreme Court did away with that and returned political power to the people and to the states and to Congress to decide this issue, as Elena Kagan now demands in this case, well, curiously, in that case, she didn't. In that one, of course, Elena Kagan joined the dissent, describing the circumstance of the people and the states and Congress deciding the issue instead of the court, quote, with sorrow. It is really cynical. It's not just the completely selective hypocrisy. It's the condemnation of the rest of us for noticing when they do it. And that's why there are two ways to view this decision, with appreciation that the majority got a clear question clearly right, or with concern that those who view the law as merely a malleable and versatile tool with which to enact their personal policy preferences aren't nearly as outnumbered as they should be, nor is this president nearly as deterred as he should be. In response to the affirmative action decision, Joe Biden declared, "This is not a normal court."
Is this a rogue court?
This is not a normal court.
This is not a normal presidency, actually, insofar as it's not one that respects the confines of the Constitution or the law. Or maybe that's perfectly normal on second thought, but that's the problem. This president has routinely taken Congress's power, disregarded Americans' constitutional rights, and indeed strategized to undermine them, and then when caught and made to stop, he just shrugs and tries again in a different way next time. He did it with the eviction moratorium. Oh, whoopsie, sorry, I just made that up and had no legal authority to do it and screwed landlords out of the income that was rightfully theirs. Oh well. He did it with the OSHA vaccine mandate. Oh, whoopsie, sorry, I just made that up and had no legal authority to do it and coerced potentially millions into getting a shot they otherwise would not have. Oh well. At least in this case, the program was paused while it was litigated, so no debt was actually unconstitutionally relieved. But given the track record, we all know what Biden and the White House were doing. They knew this was bogus and unconstitutional the whole time. They knew it stood no chance of survival in the courts, but they did it anyway because they know there are no consequences for wiping their asses with the Constitution, and because they saw an opportunity to dupe younger people for votes. Because there is a reason that this magical new legal power was suddenly discovered right before a midterm election in which their prospects were poor. They needed a boost for themselves. They didn't care about the supposed boost for you that they were advertising. That was never going to happen. It was just a move in pursuit of their own political power, nothing more, as always. And until we wise up enough to realize that the next goodie bag giveaway will be the exact same ruse and empty promise in pursuit of their own power, we will keep allowing these people more unaccountable control of our lives while we wonder and make excuses about why it doesn't ever get any better. Because it doesn't get any better until you say no with enthusiasm. Even the mentally defunct Joe Biden understands that lesson.
How involved were you in your son's Chinese shakedown text message? Were you sitting there?
No.
And it shouldn't be too much to ask that we match that basic level of wisdom, because that is a mind that's not understanding much of any complexity at all. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Minds. That is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.